So welcome everybody, thank you for being here. Episode 1 of Blockchain and the Law. We'll be discussing cryptocurrencies, blockchain, their effect on the markets. And here we have some of the brightest minds in the legal game. Why don't you guys go ahead and introduce yourselves and we'll get right into it.
Josh Garcia, I'm an attorney at Cooley.
Conor, I'm an attorney at Overy.
Kevin Scanlan, partner at Levin.
Scannavino, founding partner at Scannavino.
So as we all know, we've been watching the news. We've seen comments from Jamie Dimon, Ray Dalio, founder of Bridgewater Capital, biggest hedge fund in the world, Warren Buffett. They've all come out and had interesting comments about Bitcoin, ICOs, where we are in the market, potentially a bubble. And then at the same time, we have the founder and inventor of Ethereum, Vitalik Buterin, actually say that the majority of these ICOs are potentially scams. So the question I'd like to start with the panel is, where are we from a regulatory perspective? And where are we going? Conor, if you'd like to field it first.
I mean, I think it's interesting. It's very much an international problem, if you could call it that. I think maybe it's worth focusing on maybe some of the more recent developments in China, for example, the complete ban of cryptocurrency and the content exchanges. I think you've seen regulators across the globe come out with issuing statements saying what I think most competent lawyers already knew, which is many of these tokens may represent securities or financial instruments in the relevant jurisdiction. We've seen that most recently, I think, in Australia, also the UK, many other European jurisdictions. The SEC came out with their DAO report earlier in the summer. So I think it hasn't necessarily changed the game, but I think there have been a number of potential projects. Some have been, extremely transformative. I know Josh and Cooley have been working with Filecoin, which I think is one of the more exciting ventures. But there have been, and there continue to be a lot of tokens that are being proposed that, frankly, are likely to be securities and regulated as such. And I think there's a difference there between the expectation and the reality. And I'm not sure that the market is necessarily caught up with that.
So with respect to Filecoin, so please correct me if I'm wrong, Josh, they raised about $250 million in a regulation D offering in about 48 hours?
It's never as short as the time suggests. Because those 48 hours, you take several months of, reaching out to investors and building hype and, building prototypes of product, developing white paper, etc. But yeah, I mean, when the sale actually started, they already had around 3 million, or I forget the number, but a certain number committed. It's publicly filed now. You can look at Form G and see what the initial round of the SAFT was. SAFT is the agreement that they used to sell these tokens to accredited investors.
What does SAFT stand for, and kind of how did it come about?
So the SAFT is a way to sell to accredited investors in finding a groove in securities laws where what you're doing is you're selling essentially tokens to people, blockchain tokens, but they don't get them right away. So the SAFT stands for a simple agreement for future tokens, and it's designed like a forward contract. So the investors pay money now, and with that money, you expend efforts to bring them value. So you build this blockchain network for them. And when the network is developed and finished, then they get the tokens. And so it's kind of an elegant, simple commodities forward contract that is designed to be a security, because the funds that are coming in, the investors they're taking a risk that they're not going to get anything. It's potentially going to be the case that the funds will go to no use. That people will take the money and go to, what I said to you guys earlier, like fly to Dubai and just have a fun little week and spend $50 million, right? That could happen. So the investors are putting up risk capital, and as the reward for putting up that risk capital, they get these tokens, and that economics, where the money's put up at risk, is what gives you good arguments that the SAFT is actually a security. And so because you're selling a security, you have to do you have to find an exemption under securities laws, or you have to register with the SEC. And so what Filecoin did is they sought an exemption. So So the exemption that they got was under Regulation B, which is a way to sell to accredited investors, raise as much money as you want, sell to as many people as you want, but not have to register with the SEC, like you're not going public.
So can you just speak to what an accredited investor is and kind of who can get involved? So the file point sale there is $250 million, but it was only to accredited investors as opposed to non-accredited.
Yeah, I mean, does someone else want to cover the accredited end?
Yeah, I can talk about it. So generally for individuals, it's 200,000 in income for the previous 2 years and reasonable expectation to have it for the next year, or 300,000 joint with your spouse. There's also a net worth element of $1 million. And there's specifics in there as far as how you value your home and that kind of thing. But generally think about 200,000 to 300,000 of income or $1 million of net worth, and that's kind of the target. And I guess maybe circling back a little bit of sort of why this all came up. So when you're thinking about doing a token sale, a big issue came out as to whether these tokens actually constitute a security. And under securities laws, if you issue a security, you either have to register it or you have to put it under an exemption. And so when you look at what is a security, these tokens don't really fit well into the definition. It's a very long definition under securities laws that includes things like stock in a company or a note, evidence of indebtedness. There is one term that says investment contract. And so that is what seems could be relevant when you're looking at assessing tokens. And so a lot of what we do as lawyers in this space, in the security law analysis, is are these tokens investment contracts? And the more that they look like investment contracts, the more it looks like a security, and then you either have to register your token with the SEC or fit it under an exemption. The SAFT, as Josh was saying, came about because, and we might get more into the test on how to figure out if something's an investment contract, but generally, if you're selling a token before the network is actually live and built, and the token holders can actually make consumptive use of it, it starts to look more like it might be an investment contract. And so the SAFT model allows a company to raise that early fund to build out the network and do it in a way that complies with US securities.
So with respect to the SAFT and only being sold to accredited investors, there are some people in the market who aren't accredited investors that maybe did really well with Bitcoin, Ethereum, something potentially not classified as a security, yet they wouldn't really have the opportunity to invest in a SAFT type financial instrument. So it's being said that that can affect decentralization, as a significant portion of the tokens are essentially centralized to wealthier people. So my question is, and I don't think there's an answer for it at the moment, perhaps in an order of magnitude, what is the ideal amount of future tokens to sell in a SAFT such that you could still maintain a level of decentralization amongst non-accredited investors when they do become tokens?
I mean, the fact that like a limited number of people get tokens at the outset could lead to that conclusion, right? You could think, oh, it's in the hands of the few. What happens in practice, so this is more the business side of it than the legal side, there's a lot of strategic partnerships that get formed among the earliest people who invest in your platform, the people who help you out early on. Sometimes there's agreements to lock up the tokens for a certain period of time so that you're not flooding the market. Sometimes there's vesting so that when and this is what PowerPoint did. So there's a linear vesting so that when you commit yourself to holding on to the tokens for 3 years, and that's a form of making sure that the interests of the investors, even though it's fewer than the world, the interests of the investors align with the overall interests of the company that's developing the network, because they also want to see the success of the network. Every decentralized network lives and dies by network effects. So Facebook lives and dies by its network effects. It's true that you need the more broad and widespread the distribution of, and use of the tokens are, the more secure the network tends to be. And so, if you're an investor and you care about the network, and you have provisions and contracts that force you to care about the network, then you want it to reach that point. You want it to get to that point where it is fully, truly decentralized. And you do, and a lot of these strategic partnerships are, people who have YouTube channels, who do reviews of tokens, people who are, what's it called, like PR specialists also that offer partnerships. There's technical advisors, code auditors that provide essential support to really build, in some ways, hype, but also trust that the token is the thing that's worth supporting and the ecosystem is worth supporting. So all those things exist when you have even, not all the time, right? But they can exist when you have funds go to